Ms. Joan Pereira.
Speaker, sir, one of the biggest challenge in getting victims of sexual and child abuse crimes to make a report is the humiliation that they may be subjected to in a court of law. This is more so in an Asian society where a woman would be very embarrassed to relieve the trauma that she had undergone. Worse still is the fact that they could be cross-examined and asked questions which are very personal in nature and be dragged into a sort of exchange with another unknown person, namely the defense lawyer. While I may not be legally trained, I know the defense in cross-examining a victim is trying his best to establish his client's innocence. But sometimes these questions can be so cutting that they become more than an examination of facts relevant to the case. The amendments strike a proper balance between two objectives: the objective of ensuring that an accused person is given the opportunity to confront his or her accuser, and the objective of protecting victims from uncontrolled, unnecessary, and humiliating questions. The possibility of having to put up with the humiliating and sometimes cruel scrutiny from the lawyers is a common reason why sexual assault victims do not report the crime. In the US, there was a case involving a student from Stanford, who was accused of committing various sexual offenses against an intoxicated victim. The victim was asked many unnecessary questions. She was asked about her appearance, whether she drank alcohol, and whether she had a history of cheating on her boyfriend. In her victim impact statement, she recalled how badly the offense affected her and her ordeal of testifying in court. There was at least one occasion in Singapore where defense counsel had told the victim that he was going to ask her more insulting questions during her cross-examination. This was right after she had informed him that she felt very offended when he had asked her to stand to assess how attractive she was. In this case, the presiding judge had harsh words for the counsel. May I ask what recourse a victim has if she felt that the counsel had ridiculed her to the point of disparaging her reputation during a court hearing? Or would the presiding judge be consciously on the lookout for lawyers who pursue an irrelevant and salacious line of questioning? If I may emphasize, it is important for the investigators to be fully conversant with procedures and protocols when taking DNA samples and other evidence. We have read of a number of cases where scientific evidence could not be tendered or were rejected because the lab tests could not be done or could not give any conclusive result because of certain lapses. From media reports, I recall this has happened in a few cases. I hope the investigators follow the procedures very closely when collecting evidence. The use of video-recorded statements in lieu of oral testimony is good, because this will mean that victims will not be required to retell their horrific experience during the examination in chief. With pre-recorded evidence, the time that a victim will have to spend in court testifying will also be cut down. May I ask whether a victim can be given a choice of whether to give a statement via video or in writing? There may be situations where the victim is very uncomfortable with giving a statement on video or is unable to recount the alleged incident accurately because he or she is traumatized. What measures will be taken to ensure that victims are not disadvantaged by being made to give a statement on video in such situations? Lastly, I note that the expansion of the community-based sentencing regime will mean that a greater number of offenders will be given access to rehabilitative opportunities. This amendment is to be welcomed, as it is a continued recognition of the fact that not all offences are best addressed through the traditional sentences of imprisonment and fines. Some offences may be committed in a moment of indiscretion, and thereafter the offender may demonstrate a strong willingness and ability to be rehabilitated within the community setting. There are some offenders who commit offences because they are unwell mentally. Medical interventions rather than punishment should be the focus in such cases. Mandatory treatment orders, or MTOs, address the root of the offending behavior by ensuring that such individuals receive treatment. The expansion of MTOs as a sentencing option for more offenders and offences is thus a welcome change. I would like to ask, which offences punishable with up to 7 years imprisonment will MTOs be applicable to? What is the criteria for determining the prescribed list for such offences? The ministry has said that community-based sentencing have been frequently imposed and have been successful in achieving their objectives. Can the minister share the uptake rate? Sir, I support the bill. Thank you.